Hello, everyone. My name is Woo Kang. I'm working for Korea Maritime and Ocean University. You can find out my names in the website of Korea Maritime and Ocean University. And today, I'd like to talk about Korean system of public law. It's not about maritime law, it's not about the fishery law you are dealing with. But I want to briefly introduce Korean system of public law. In fact, the scope and the scope of public law is very big and very has many issues in there. So it's impossible for us to deal with those such a kind of many issues and all part of public law. It's impossible. So I want to let you understand and experience how the lawyers deal with the legal cases, especially in the public law area. Right? Here we go. The Korean systems of law has its origin mainly from Japan. Actually, it is Japanese system, and also if you can trace back to far more than you can meet the German system. It is because Japanese people, Japanese governments, in the past time, more than 100 years ago, they adopt their legal system. They adopt their legal system from Germany because they think the German system is very good for them to stabilize their society and their country. So German system come to Japanese legal system, and as you know, Korea was colonized by Japan for 36 years. At the time, Japanese people bring their system into Korean system. So Korean people get accustomed to German types of, more specifically, Japanese type of legal system. As it is called a continental legal system. So Korea mainly adopts continental legal systems now. On the other hand, Korea also influenced by the Anglo-American common law system. From the World War II, the troops of the United States, after winning the war, they come to Korea to liberalize Korea, and they introduced their system instead of very dictatorship-like Japanese system. So the Korean legal system, especially as a matter of criminal law and criminal procedural, we adopt some part of Anglo-American system. From that times, we are heavily influenced by the American legal system. The continental civil law system, continental legal system, has its form of legislation. Legislator codifies a lot of statutes, such as Code of Civil Law, Code of Criminal Law, Code of Criminal Procedure. Then the judges in the court system should follow the rule and standards which is legislated by the Korean Congress. And also, as I mentioned, Korea was influenced by the Anglo-American common law system, especially as a matter of the principle of due process. These days, the due process is a very big deal in Korean public law and Korean criminal procedure. Also, Miranda warning, exclusionary rules, hearsay rules, sentencing guidelines are adopted, introduced in the Korean legal system. So, especially after 2007, Korea aggressively tried to implant Anglo-American system into our continental civil types of system. So now Korean legal system is changing a lot. Next. To understand Korean law, you should look at how it is classified. The first type of classification of Korean legal system is the private law and public law. Today, yes, we are going to mainly deal with public law. However, you should understand the private law because private law is the starting point of the modern legal system. Public law is kind of the subsidiary to the private law, strictly speaking. But there's another types of classification of Korean legal system. There are private law, of course, there are public law, but also there are social law. Do you know, have you ever heard about social law? Yes, I think your country also adopts the system of social law. Social law is not a private law or a public law, but it has very unique and very special meanings in our society. Why don't we deal with the private law first? You can freely make any type of agreements, contracts with another private persons, as long as it does not violate another's rights or interest or mandatory provision in law. It is called laissez-faire. Laissez-faire is from the French, but it means leave me alone. Do not touch me. Even though you are very authoritative state power, you cannot touch me. I will freely form my personal and private transactions with other people in our society. This is my area. That is the first principle of private law in Korean law, because Korea is established as based on the ideology of liberalism. Private law regulates a legal relation between private persons. As I mentioned, in the area of private law, a legal relation is formed based on a free and autonomous decision of an individual private person, which cannot interfered by any other power, any other powerful persons, or any other authoritative state power. All right? The private law, let's divide the private law into subsidiary categories. There are civil law and commercial law. The civil law contains contracts, property, and family law. The contracts means kind of the legally binding agreement by more than two private person. And the property has the substance of protecting somebody's property from any other interference, any other invasion. Also, there are family law. Family. You cannot freely form all kind of family, but still you can freely choose to marry another person. So family law regulates the private area of family relations. And also there is commercial law. Commercial law regulates the personal transaction, private transaction, especially between merchants. So the civil law and commercial law are the very representatives of private law area. So a legally binding effect of contracts just follows a voluntary agreement between individuals. However, once you sign on contract, you are legally bound by the wording on it. You cannot escape from that. So you have to be cautious before you sign on the contracts. Once you choose to get a contract, then you are legally bounded. That can be enforced by court process and any other governmental power, because you freely chose to come into the contract. All right. So any kinds of private law, any bounding powers of private law should be supported by free decision. That is core concept of private law in Korea. So why don't we move to social law area, social law issue. Social law belongs to neither private law nor public law. It is very unique and a third zone of contemporary legal system. It was developed relatively recently, especially after World War II, especially after Great Depression. People thought at the times we need a protective measure to use government power for everyday lives of citizens. There are labor law and social security law. Labor law and social security law are the very representative of social law. Labor law is about regulating the relation between employer and employee. And the social security law is dealing with protecting poor and impoverished people who do not have very good method to live their lives in our society. In the labor law area, a private contract between an employer and employee is not subject to laissez-faire. It's not leave them alone, but is seriously regulated by mandatory provisions. For example, an employer or an employee cannot decide a minimum level of wages, even though an employer and employee reached a very faithful and sincere agreement about the minimum wages. They cannot go down under the level of minimum wages. Korean government has the power to decide it. Also, an employee can quit his work anytime he or she wants. Employee can leave from their workplace anytime they want. But an employer cannot repeal their contract without satisfying the very, very strict requirements of Korean labor laws. That is the most different aspects of social law, which has many mandatory requirements to enforce. Generally, social law is about rebalancing powers between the stronger and the weaker in our society, instead of simple laissez-faire, instead of leave them alone. So now we are going to deal with the public law, which is the main topic and main issues of today. Public law regulates the legal relation between states or between a private person and a state. So a party should be a state, which can be a public law. On the one hand, the public law is about state action for states or a private citizen. There are many types of public law in Korea. There are constitutional law, criminal procedural, civil procedural. Wait a minute. Why the civil procedure is classified as public law? You can raise that kind of questions. As I mentioned, we already deal with the civil law. Civil law belongs to the private law. Why did I classify the civil procedure as public law? Because civil procedure is about rule and standards of court process. When substantive civil law was violated. When somebody violates their contracts, then another party can sue him to Korean court. The Korean court become one party. So it can be said that the civil procedure is part of public law. And also there's an administrative law, administrative regulation rules. Administrative law is a real core of public law. You can say that. And also there's the ordinance of local government. The ordinance of local government is not a statute. It can be just enacted by the local legislators. It is a very lower level of statute, but still it is law. So these days, local governments work very hard, so there appears many types of ordinance which regulates everyday of citizens. So we have to take care. We have to be cautious about the ordinance. If you walk down the streets, or if you drive a car, like that. Beside of these examples, there are much more sort of public law in Korea. In the past time, especially when a civil revolution started, there are rare principles of autonomy in the public matter of law. The autonomy in the area of public law was not considered seriously in the past time. Administrative powers in public law were mainly dealt with based on the rule of law. Rule of law, some rules in the area of public law. There was no autonomy, there was no freedom taken seriously. However, things are changed. But in the continental system of law, you can find out the legal terminology referently case rate. It is from Germany. As I mentioned, our system comes from Germany. So this terminology was translated in Korea and used in Korean public law. If it is translated in English, it can be called public right or power. However, basically, in the Anglo-American legal system, there's no distinctive understanding for the concept of public power. There's no special position of public power, which an administrative body may especially or exceptionally exercise. Basically, in the American legal system, an administrative body can form a legal relation without any difference than private person. So, in the Anglo-American legal system, the public power or government power cannot argue that I have superior power over every single citizen. They cannot argue like that. They have the legal position just the same levels with normal citizens. All right? The principles in Korean public law has been formulated following the ideology of liberalism. the liberalism start to argue for their existence, especially after 1980s. There was very liberalization era in Korean history, especially after the civil rights movements, as I mentioned, in the late 1980s. It's not simply Korean public law that orders mandate any behavior for a citizen. It means we do not understand that Korean public law has a power to mandate any citizen, any normal citizen, without any reasonable and rational grounds. The concept of liberty, so for the individual citizens, becomes the main source of the Korean public law. I want to intensify this point. So now, why don't we deal with the case? Dealing with case is the real moment of law. I think law is not just simply formally codified in the documents, in the government documents. Law can be alive in the real case, in the real legal case. Let me show how a lawyer usually deal with the case. Let me read the case one first, and just follow my reading and think about what is issue in this case. I usually use this kind of methodology in my undergraduate classroom. I ask a lot of questions after showing this kind of cases and ask students, what is the issues? Please raise a question after reading this case. Let me read it. A man runs a karaoke room. He usually provides his male customers with women who assist to sing together with them. He promised his customer in the night to have a girl to enjoy. In the karaoke room in question, the woman became half naked but merely wore her underwears. But there was no proof of any physical contract between woman and customer. How do you think about this case? Do you like to be happy with this case? Or you feel a kind of disgusting by reading this case? You have sense of justice, actually. I always intensified, emphasize on this point. You have sense of justice, and there is a theory of justice. Theory of justice is mainly proceeds with very formal requirement and concept. But sense of justice do not require any kind of the very formal and strict requirements. So everybody who do not experience, who have never experienced law or legal methodology, can determine whether a particular phenomenon is right or wrong. That is sense of justice. Based on your sense of justice, is that okay for you? Probably many people feel uncomfortable of this case. It is not, then we can say that, it is not a very desirable phenomenon. It's not very desirable events. Then some part of action in this case should be prohibited, may be prohibited. because it does not look very desirable. How the Korean court decide this case? Korean Supreme Court decide that we cannot say, our system have no say, no idea about prohibiting any action in this case. What is issue of the case first? What is the issue of the case first? Let me show you one example of issue. It's not ideal types of unique and ideal types of raising issue. It is just example of raising issue. Does any act of prostitution happens, which is totally prohibited in Korean criminal law? That is first issue. Because to analyze the case one, you need legal requirement, which is provided in the Korean criminal law. Is there any prostitution happens in the case? Did you see that? Yes, similar thing happens. But nobody can say there happened actual prostitution, because the meaning of prostitution, the concept of prostitution contains meaning of sexual intercourse in exchange of money, right? Without satisfying that requirements, that legal wordings, you cannot punish anybody for prostitution. They did not do any prostitution in this case. They just give and takes money in exchange of kind of amusement services by a girl. But still, we feel it is uncomfortable. And how should we deal with that uncomfortable sense of justice? Let me show another types of issue. Is there any indecent act that is not allowed to do in the space when someone run a karaoke based on Korean administrative law? There's another angles of raising issue. The first issue was about Korean criminal law. So whether this case can be subject to criminal punishments. But in the issue second, I did not raise the criminal punishment issue. I just want to raise Korean administrative law issue. There was some provision in Korean statutes. You cannot do any indecent acts by running karaoke, by running hotel, by running any kind of restaurant like that. Is there any indecent act? Yes, probably. Surely there was no prostitution, but we can say that there may appear an indecent acts. What was the Korean Supreme Court response against this argument about this issue? The Korean government decided that there was no indecent acts in the case first, within the meaning of the particular Korean administrative law. Why? And then let's move to another issue. Let's move to another issue. Is the private agreement valid between the host and customer about getting a girl help to sing in the karaoke? Why don't we move to the first part of this lecture? In this class, I already told you, if you do not invade any other's fundamental rights, any other's civil rights, or if you do not violate any very serious social values, your agreements can be freely formed, and you can make any kind of transaction with your fellow citizens. Then is there any, in the case one, do you think is there any kind of indecent act that violates our social value? Pro-liberty. Even though we are not simply a little bit uncomfortable about this kind of acts, but still, Korean Supreme Court declared that there was no indecent act as a matter of administrative law as well as civil law, contracts. All right? Pro-liberty. What is the meaning of the liberty? We clearly feel that it was not very comfortable. But still, the Supreme Court raised the hands of the guys who did the acts which is not accepted as very comfortable and desirable. Because liberty is the core and the main ideology of our society. That ideology come deeply into our legal system. So slightly you can feel uncomfortable about a particular acts or particular phenomenon. But that acts or phenomenon, if that act or phenomenon belongs to areas of liberty, nobody can touch it. Nobody can touch it. Every single citizen has their own kingdom, which cannot be invaded by anybody, any fellow citizens, or even very authoritative governmental power. That ideology incorporates into not simply the civil law area, in the private law area, but also into public law area. All right. So within the public law, the most higher level and representative types of law is constitution. Korean constitution was established after we were emancipated from the Japanese colonization. Our constitution has many chapters. Chapter first is about general matter. Chapter second is about citizens' fundamental rights. Chapter from 3rd through 8th, governments, the structure of governments. Chapter 9, economy. Chapter 10, the amendment of constitution, the process and the rules and standards of amendment of constitution. Which part do you think is the most important in the constitution? I already emphasized on that point. Yes, chapter 2nd is the most important part in the Korean constitution. I think citizens' fundamental rights. The most basic structure, basic grounds to establishing the building of Korean legal system.